CR233-57217, the people of the state of Michigan versus Jalen Johnson. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more for less than $20,000. This matter is scheduled for examination.
Good morning, Your Honor. Adam Bookler appearing on behalf of the people, P 86266.
Good morning, Your Honor. Sophia Nelson, American Defender Service, on behalf of Mr. Johnson, P 77960. Mr. Johnson, subject to report. Mr. Johnson, please state your name for the record.
Good morning, Your Honor. My name is Jalen Johnson.
All right, thank you. Are the people ready to proceed?
No, Your Honor, the people did not have paper discovery in this case. He met our officer in charge multiple times for a copy of the jacket, never heard back, so we're unable to provide it to Attorney Nelson for Mr. Johnson's defense. So the people are unable to proceed, and there's a discovery issue.
Judge Giles did sign a discovery order in this matter, so we move to dismiss at this time.
All right, so there's the time for preliminary examination. The people, I'm assuming you didn't have anything to move forward with. You don't have anything to move forward with, and you weren't provided with anything. So this matter will be dismissed. It'll be a dismissal without prejudice. People can refile should they be able to move forward at a later date. All right, thank you. All right.
I think.
Okay.
Thank you, Judge.
Okay, I'll check back with you.
Okay. Yeah. Yeah. Wasn't on witnesses.
I have a question.
Yes.
If I'm gonna play a video, how do I go about cooking?
You gotta, you have to share it, like you would Zoom it.
So go on Zoom and do it.
Yeah.
Oh, okay, that's easy. Now I know how to do that.
Can you give Miss Shauna? Mr. Washington. Oh, thank you so much. Mr. Washington, can you hear me?
Yes, I can hear you.
Okay, you're on Giles, correct?
That's correct. Yeah. Is
Okay.
Mr.
You know,
Giles, is it?
wait.
Okay, he's in
Go
custody,
ahead.
isn't he?
Yes, he is. They said they couldn't put him on because of a mental issue.
Okay,
So Judge Debris is on her way down.
okay,
Yeah.
Just waiting on the fence.
I know, that's been horrible. Hey, hey. Mr. Washington, is April 28th a good day for you?
okay. Let me just check that and see. April 28th. Yes, well, it depends on what time. I have some matters over in circuit court.
I'm open. I got slots all day. What's a good time?
Okay. Now is this for a preliminary examination?
Yes.
Okay. Let me see. Is it is 11:30 all right?
Yes, that's the last time slot. Yep.
Okay.
This is Mr. Lucky. Right. He's pretty. That's a joke.
Okay.
We don't know.
Now is that going to be put on the record?
Um, hold on, Mr. Washington.
Okay.
Yeah, of course, yeah.
Mr. Washington,
Yes.
do you have discovery?
Yes, I have discovery.
Okay, there's no discovery issue?
Well, I appear to have digital and paper discovery. I'm assuming that's complete.
Okay, I was gonna say I can give you just your date as long as there's no issue with discovery.
Yeah, you can give me the dates. The date.
All right,
right.
so it's April 28th at 11:30.
Okay. Okay.
And in person, you know that, right?
In person, that's right. Okay, then.
All right, thank you, Mr. Washington.
All right, thank you. All right, have a good day.
Sorry for the long wait. I didn't know that was you. You didn't have your name.
Oh, okay, that's all right. Okay, then.
And there's no way I can message somebody in the breakout, I mean, in the waiting room.
Oh, okay, then. All right, that's all right.
All right.
All right, have a good day.
All right. Huh? Yeah, I should have. I just.
Okay,
Nice to see you again.
I know.
It's a short time.
Yes.
Morning, Judge.
Good morning. Oh, good. Oh, my God, you gonna text me something?
Yes. What's, you got the other.
But you do understand. I don't know where it's.
Oh, my God. Just like a happy day. Oh, my God.
Oh, Whipple was too, but that was the same person.
She is.
Right, introduce her.
They all wrapped. That was yesterday.
Oh.
You sure it's not for tomorrow?
Oh. Right.
No, it's not tomorrow. Well, Oh, Mrs. Strong, this is tomorrow. Well,
Yep.
this is tomorrow, 11 o'clock. These are, it's Demetrius, right? Demetrius and the girl.
She won it?
Sure.
Oh, time flies.
Remember when you're on.
Weird, like slow and fast at the same time. This looks great.
Thank you.
Like at night it's slow.
Oh, I'm in.
Mr. Strong came with no one. I would say. Let's see what.
Judge Jefferson updated me, yeah, a lot.
Oh. No.
I just got done with an exam, so I'm perfect time.
Oh,
Okay.
okay. We
I'm
ready?
sorry, Judge, I really, it just wasn't,
We ready?
Yes, ma'am.
Calling case number 235. Calling case number 2356153, the people of the state of Michigan versus Sean Luckett. Defendant is charged with count 1, assault with a dangerous weapon, felonious assault, habitual offender for notice. This matter is scheduled for examination.
For the people, Philip Henderson, PA 6029.
Attorney Monique Sanford, P62315 on behalf of Sean Luckett.
And Mr. Luckett, can you state your full name for the record, please?
Sean Duvall.
Okay, everyone ready to proceed?
Yes, ma'am.
Yes, Your Honor.
Any preliminary matters?
No, Your Honor.
Your Honor, just note for the record that I intend to, and we'll present it as going forward after the direct examination, but I do have video.
So please keep your voice up.
Oh, I'm
You
sorry.
said, but I do have one.
Video that I do plan on introducing it to.
Okay. All right, you can call your first witness.
The people call Albert Antone Prenny.
Stand right over there, sir. What is your name, please?
Good morning, my name is Albert Gray.
ALBEIT.
Yes, got PRENI,
ENA.
no, I.
Thank you.
No, PRENI, I'm sorry.
Thank you.
No problem.
Okay, we have a seat, I swear you in, raise your hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Okay, go ahead and have a seat, and make sure you speak up in that microphone.
Judge, would you mind if he holds the microphone? Would you mind if he holds the
I
microphone?
was telling them that.
Okay, thank you.
Okay, can you hold it?
Hold it, yeah.
Yeah.
I'll hold it.
Thank you.
No problem.
Okay, whenever you're ready, Mr. Henderson.
Could you please introduce yourself to the court?
Yes, my name is Albert Prenny.
And, Mr. Prenny, are you a business owner?
Yeah,
And what business, are you an owner of?
D Motown Deli located at 3750 Gratiot Avenue.
And is that here in the city of Detroit, the county of Wayne?
Yes,
And on March 20, did something happen on March 27th, 2023 that brought you here to court today?
yes.
And, if you could tell us about that, what happened?
Was in the back of my restaurant working, and I noticed.
Judge, I'm sorry. If he could just sit back.
No problem.
Yeah, okay, thank you. Okay.
It's good now?
Mhm.
Okay. It's in the back of my restaurant working, when I noticed on my camera, a gentleman walk in, stand in front of the doorway. And he held the door open for one of my customers who was leaving. And I noticed on the camera footage, he walked behind him, then my customer turned around, kind of with like a negative look on his face. So then, at that moment, I went out through my back door into my parking lot. Then saw a guy with a brown and green jacket on. I asked him,
Okay, before you tell us what
Yes.
you asked him, when you were viewing the camera, did you see him with, any money in his hand?
no,
So you said that you walked out, you saw someone with a brown and green jacket. Do you see that person in the courtroom here today?
yeah,
And if you could identify him by an article of photo, point him out and identify him by an article of photo.
it's right over there. Got a black and white shirt on.
I don't know if the record could reflect that he's identified the defendant in this case.
So reflect.
So, when you engaged with him, what did you say?
Said, sir, are you trying to buy food?
And what did he say?
At first, yes, and then right afterwards, he said no.
Okay, and then what happened?
Then I said, okay, sir, well, you're trespassing. If you're not here to buy food, then you're trespassing.
And what was his response?
He said, am I allowed to use vulgar language?
Yes, say exactly what was said.
He said, don't fucking disrespect me. Then I said, sir, you're disrespecting me by being on my property, bothering my customers. I have signs in place that say no panhandling, soliciting, or loitering.
Okay, and after you told him that, what occurred?
Said, don't fucking disrespect me. Don't fucking disrespect me. I'll fucking kill you, white boy.
Okay, and then what did you do after he said that he would kill you?
Said, sir, I got cameras everywhere. You're so good they can see the whites of your eyes and you're gonna threaten my life in my parking lot. And I pointed to a sign and said, look, the sign's right there, no panhandling, loitering, or soliciting.
And after that, what did he do?
At that point, one of my customers pulled their car up. They saw me and him going back and forth. Tried to defuse the situation.
And did you know this customer from previous
Yes,
previous purchases in your stores?
yes.
And so you said he tried to defuse the situation. What was the defendant's response to that?
The defendant isn't,
Yeah, the defendant in this case, Mr. Sean Duvall Luckett, the person that you pointed out.
he began to start acting erratic, throwing his hands up and down, still threatening me. I'm gonna fucking kill you. I'm gonna fucking kill you. Then at that point, I seen him turn a little bit, put his hand in his pocket. He had his phone in his left, and then he kept changing it back, left to right, left to right. Seen him put his right hand in his pocket. And I said, what are you reaching for? Then I seen him pull out something black and chrome. At first, I thought it was a gun. At that point, I came closer. Sorry. At that point, I came closer, just in case, God forbid, if it was a gun, I would have grabbed a hold of him. As soon as I saw it was just like a knife or a box cutter, I took a step back.
Okay, let's
Go ahead.
let's ask some clarifying questions on this. So when your customer pulled up, where was Mr. Where was the defendant in this case, Mr. Luckett? Well, actually, let's back up. Withdraw that. Your store has a sidewalk in front of it, or a
Yes.
walkway in front of it, and then there's a street, right?
Yes, Gratiot.
Gratiot. So when your customer pulled up, where was the defendant standing?
Defendant at first was on the sidewalk, and then he stepped onto Gratiot, and then he pushed my customer's passenger side door.
Okay. And when you and he were exchanging words, where were you standing?
I was on the left of the defendant.
Okay. Were you in the street as well?
At one point, I was on the sidewalk, and then I made it onto the street.
Okay. And once you said that he was switching his cell phone between hands. What hand did you see the weapon in?
The right hand.
And could you describe the weapon for the court?
It's black with a little bit of chrome, foldable box cutter.
And when you said that you saw the knife, did he open it? Could you see the blade?
No, I could not see the blade, but as soon as I saw the box cutter, I took a step back. And as soon as I saw him approach me, I struck him with an open hand to throw him off balance. At that point, I proceeded to turn around and take off to the back door of my restaurant. At first, I turned around and I pointed to the defendant. Then I told my customer, look, he's got a box cutter, call the police. That moment, I took off, had my restaurant keys in my hand, unlocked my door and went inside. My fiance and my mom were at the door already on the phone with 911. I grabbed the phone, told the dispatcher the description of the defendant, asked me, does he have any weapons? Said a box cutter and a knife.
And were police officers deployed to your location?
Yes,
And were they able to locate the defendant?
yes,
And did you see him after they had apprehended him?
no,
When you were in the street and you saw the knife, did you think the defendant was going to use it?
yes.
Okay. Was he saying anything when you saw it?
I'm gonna fucking kill you, white boy.
No further questions at this time.
Just one moment. I'd be glad to see some.
Can you permit?
You got to, okay, it should.
Okay, yes, just finally. Thank you.
You gotta put your device all the way low.
I have it on mute. You hear me up here? You want me to put myself on mute? Okay, hold on. Let me stop sharing.
Now, got better.
Okay.
Sorry, Judge, just give me a minute.
No, you're fine, take it.
I'm trying to- Do you agree that in this picture, my client, Mr. Luckett, has come into your establishment? Yes?
Yes,
He came in, he had money in one hand, cell phone in the other hand.
no, I can't tell what's in his hand.
Opens the door for the gentleman, you agree that?
Yes,
Walks out and he's talking to the gentleman, correct?
yes,
And he follows the gentleman to the parking lot, fair to say?
yes,
Gentleman is walking to his car, my client is talking to him, correct?
from this point of view of the camera footage, I can't tell.
I'm sorry. Give me just one moment. It's not showing up on here. Okay, can you see that on the screen share?
Is this a different video?
Yeah,
So can we establish the first video where the entry or the which camera that was that you were asking him about?
the first camera was the door entry.
He established that with,
Do you agree that the first camera that I showed you was the entry of the door to your restaurant?
Entry door, camera angle, yes.
You agree that this is the video of your parking lot
Yes,
and the customer is walking to his car
yes,
and my client is continuing the conversation with the customer?
yes,
Do you agree that this is you now walking out to the parking lot
yes, my parking lot, yes,
and you are approaching my client?
yes,
My client has discontinued the conversation with the gentleman, the customer.
yes,
Customer is leaving.
yes,
You're exchanging words with my client.
yes,
You're continuing to change some words with my client, fair to say?
yes,
Before I switch screens. Now my client is beginning to walk down the sidewalk, fair enough to say? Well,
doesn't seem so.
my client is now walking down the street on the sidewalk, correct?
Yes,
You're walking in front of my client. The SUV is driving past, correct?
yes,
And this video was of the parking lot, oh, correct?
yes,
All right. This is the front of your building, is that fair to say?
Yes.
This would be a third.
This is the third video, Your Honor. You and my client are now in the front, and my client is talking to the person in the vehicle, is that fair to say?
Yes.
My client and this person are having a conversation. You're standing on the sidewalk, fair to say?
Yes.
My client's back is to you, he's having a conversation with the person in the vehicle, fair to say?
Yes.
You are still standing there, you have not left, and my client is continuing to talk to the person in the vehicle, correct?
Yes.
You have now stepped off the sidewalk and you are now talking again to my client.
Yes.
My client is in the street talking to this man in the vehicle, correct?
In front of my building, yes.
And you are continuing to engage in conversation with my client, correct?
Yes.
You go back to the sidewalk, you come back into the street just now, and you're continuing to have conversation. And your arm is waving and you're having conversation with both my client and the person, and now you have punched my client.
No,
No, you didn't just punch my client?
I did not punch him.
Oh, okay, well, let me back this video up.
I struck him with an open hand.
You see my client with his cell phone in his hand, correct?
I can't tell. The video's blurred.
And you just said that you struck him with the open hand.
Yes, I struck him with an open hand.
Would you like me, can I replay that for you one more time, Jeff?
It's a glare on the TV. Do you know which light? Or which switches?
It's just the, well, turn that one on, flip that one up, and turn the other one. It just might just be dark. And turn on.
Okay.
There we go. Thank you. Just for the video.
Yeah.
Okay. If you could play it again.
You would agree that that's the end of that video, correct?
Yes.
And you strike someone with the open hand, your hand would have been like this. You agree that this is what an open hand looks like?
No.
You're demonstrating with your open hand waving thing.
demonstrating with my open hand waving back. And you see my hand?
Yes,
Hitting somebody with an open hand is to have your hand open and hit them. If you close your hand, that is no longer an open hand. This is a fist.
Is that a question?
Do you agree?
can you please rephrase that?
If I'm swinging my hand like this, would you agree? If I hit somebody like this is an open hand.
And for the record, you're signaling with your hand open, moving
And
left
I'm-
to right.
Thank you. Yes?
Yes,
If my hand is like this, my hand is closed. And if I move my hand from left to right, I am now hitting someone with a closed hand.
yes, you would be.
The video shows that your hand is closed. It does not show your hand wide open like mine. Do you agree with that?
May I
Just answer.
demonstrate?
It's a yes or no.
Yes or no?
Can you please repeat the question? I'm sorry.
The video shows your hand closed and you hitting from left to right with your hand with it closed like this. It does not show your hand open like this. Is that correct?
No,
Are you saying the video is lying?
I'm saying if you zoom in on the way my hand was not closed in a fist. It was like this, an open hand, like I had stated previous.
And would you agree? My client's right hand is behind him. My left hand, his left hand is on the side of him. He is not facing you, he's sideways to you. Would you agree at that point?
No,
At the point you decide that you're going to hit my client, both hands are down to his side.
no,
And then,
at that point,
and
yeah.
then his right hand goes behind his back. Do you see that?
Yes,
Okay. While his hand is behind his back, you swing, correct? That's what,
yes,
okay. So my client's hands are first by his side, then his right hand becomes behind his back while he is standing sideways to you, correct?
yes,
While his hands are either to the side in the process of going to the back, you swing and make a connection and hit my client, correct?
yes,
Okay. And then you take off running,
yes,
and then my client takes off running.
towards me, yes,
And would you agree with the fact that he does not continue to run, he just runs into a piece of the parking lot and turns around and walks away?
after I had already made a fair distance away from him, yes,
He doesn't pursue is what I'm asking.
he stopped pursuing me,
Okay,
yes,
all right. And based upon the video, you initially have a conversation, you think my client is harassing your customer, and you ask my client to leave, correct?
yes,
And then my client walks down the sidewalk and he engages in a conversation with a person in an SUV in the street.
yes,
And you don't leave, you continue to stand there, correct?
yes,
And my client stays in the street the whole entire time talking to the person in the SUV, is that correct?
yes,
And you leave off of the sidewalk and you step down in the street and you continue to engage in a conversation, although my client is talking to the person in the SUV, is that correct?
yes,
And then you walk back
You stand back on the sidewalk and you continue to stand there while my client is talking to the person in the SUV. Is that correct?
Yes,
And then you decide to come back off the sidewalk, back into the street, engaging my client again. Is that correct?
yes,
And you are pointing your finger. You are very vocal at this point. Is that correct?
yes,
And then you walk back towards the sidewalk again. Yes?
yes,
And then you turn back around again while my client is facing the SUV, talking to the person in the SUV. Is that correct?
yes,
You walk back up again towards my client. Is that correct?
excuse me?
You walk
Repeat
back
that.
up towards my client who is at the SUV. Is that correct?
Yes,
My client turns back around, looks at you again, correct?
yes,
You all are exchanging words. My client's hands are down at his side. Yes?
no,
I just asked you this and just showed you on the video and you said yes. Are you
Okay, Your
changing?
Honor, then I would object to this asked and answered.
I'm now just going through the sequence, Your Honor.
What's the answer?
No problem. My client at no point ever swung at you. Is that correct?
yes,
My client at no point arms were, when before that swing, ever towards you. Correct?
no.
All right.
Multiple occasions.
I just answer the question. Don't offer anything additional.
If my witness can have a chance to explain his answer.
He
after the
doesn't
answer,
get a
yes or
chance to
no.
do that. It's a yes or no.
That can be done on redirect. The question is yes or no question.
Yes, Your Honor.
Now, you testified that at some point you felt like you saw something black and chrome, correct?
Yes,
And you indicated that you thought that initially you thought it was a gun, but then you began to think it was a box cutter. Is that correct?
on closer inspection, it was a box cutter, yes,
Okay. And your own testimony was that the blade was not out on this box cutter at that time, correct?
at that time, yes, correct,
All right. And you decided at the point that you saw that it was a box cutter, that you were gonna hit my client. Is that fair to say?
yes,
And at no point did you ever see that blade on that box cutter, did you?
at that moment, no,
Okay. And you left. You took off, you took flight. Is that fair to say?
fear of my life, yeah,
Fear of your life, fear of your life. You're the aggressor, but you were in fear of your life.
Objection,
that
Your Honor,
fair
it's
to say?
argumentative that he was the aggressor.
In his argument, if it's not in facts.
I'll save it for argument, yeah. Move on. And then you run, you go in the back of the store and 911 is called. Is that fair to say?
yes,
No further questions.
Redirect.
Yes, Your Honor. Mr. Prenny, when you were speaking with the defendant in the street, you were animated.
yes.
Why were you so animated?
Because I asked the defendant multiple times to leave my property, because he was not conducting business.
And you talked about on cross-examination that his hand was back. What was in his hand at that
The
point?
box cutter,
And based on your perception, why was his hand pulled back? To assault me.
caused harm to me,
Okay, and that's what you thought he was going to do.
yes.
Okay. Why did you run?
I was in fear of my life. My restaurant's a safe place, so I fled to get safe.
And what was your perception of why the defendant stopped running? After you.
I was multiple cars in my parking lot, people leaving at that moment.
Objection, that's speculation to ask him why he stopped running. He doesn't know what was in the mind of my client.
I'll rephrase your honor.
Okay, thank you.
Did you notice that the defendant stopped running once you reached safety?
About halfway in my parking lot, I made a good enough distance where I'm not in the defendant's mind. I guess he just gave up.
He wasn't going to catch it.
No,
And did he make any threats during this altercation?
Not that I can recall.
From your entire conversation, did he make any threats?
Yes, multiple.
And what were those?
I'm gonna fucking kill you. I'm gonna fucking kill you. I'm gonna fucking kill you, white boy.
Did you believe that he would actually do that?
At first, no. But when I saw the box cutter in his hand, then yes.
Nothing further.
You can step down, so you're all set.
Thank you.
Have a seat in the hallway. Or can you be released?
Yes, sir.
Any other witnesses for the people?
No, Your Honor, this time the state rest.
Any other defendants?
No, yeah.
Okay, Mr. Anderson, you can begin argument.
Your Honor, the evidence proves by a probable cause standard in this case that the defendant attempted to, or he did something that would cause a reasonable person to fear that there was a threat of an immediate battery. He had a box cutter. The victim saw it while his hand was back. And that's common. If you're gonna stab somebody, get some momentum so you can stab him. So he had a reason to believe, and a reasonable person would have believed that there was an imminent battery. And through the multiple threats that he was going to, in his words, fuck him up, he did believe that there was an intention to injure, and that there was going to be an immediate battery. He perceived that the defendant in this case did have the ability to. He saw a weapon, and he was pursued even after he struck the defendant, as he has stated, with an open hand. And the weapon, as he described it, a knife with a blade would be a dangerous weapon. And so we believe, according to the victim's testimony in this case, that it presents a question of fact to be decided by a jury, and the probable cause standard should have met.
That's it, sir. What is clear to me is my client goes into this establishment, he has his phone, he has money in his hand, he engages a conversation with a customer, let him and that customer have a conversation. This owner from off jump decides this black man is gonna be a problem. He goes out, he confronts him. My client stands there. You don't see my client making any aggressive actions. He walks away from him. He walks up to an SUV. You don't see my client making any aggressive actions. This store owner continues to stand outside. My client is not on his property. He's not defending his property because he's not on his property. He left the parking lot as asked. He stands out in the street, which all day long is public. He has a right to be in the street. He engages the person in the SUV conversation. This store owner steps off the sidewalk. He goes up. He's the one waving his hand. He keeps on talking. My client turns around, speaks to him, turns back around, continues his conversation. What does the store owner do? He still will not leave and go in his store and tend to his store. He's the one that decides. He goes back up on the sidewalk. He steps back into the street. He continues to confront my client and the person that's in the SUV. My client turns back around, says a few words. You see my client's cell phone. He turns back around, continues his conversation with the person in the SUV. My client is minding his own business. Does this store owner stop? No, still not good enough. This store owner comes back out in the street, comes back up on my client, continues to have words with my client. What does my client do? Turn around, look at him, say a few words, turn back and face the SUV. Store owner walks away again, still will not leave, comes back and fronts my client again. My client is standing sideways. If you believe his story, both of my client's hands are down to his side. Store owner says, well, I thought it was a gun, but upon further inspection, it was a box cutter. On his own admission, he saw no blade. There was no blade pulled out. On his own admission, my client never waved that box cutter. He didn't point it at him. He did nothing aggressively towards him. My client is in fear of his life. What does this store owner do? You see clear as day. He hauls up and punches the mess out of my client. My client falls back, his hands fly up in the air, they come back down, he runs for a brief second, and he turns around and leaves. How was this man in reasonable fear? If he was in reasonable fear, he should have been in his store. He could have been in his store. He had plenty opportunities to leave this man alone. The store owner refused to leave my client alone. He refused to go back in that store. He refused to, if he was scared, go to safety. His go to safety was to punch my client. He's the aggressor. There was no reasonable fear. He did not even see a blade. Ever did he see a blade. There is no probable cause to establish that my client committed a felonious assault, and I'd ask this matter be dismissed. This is a miscarriage of justice that he was even ever charged.
Your Honor, if I may respond, the aggressive actions by the defendant was that he was bothering the victim's customers. He was in the victim's parking lot, and as fellow counsel has pointed out, the defendant does have a right to be in the street. The victim also has a right to be in the street. It's public property. That cuts both ways. The victim testified that a customer was the one in the car, and by his perception, continued harassment of the customers, of his customers. The defendant was saying a few words. Those words were that he was going to fuck the victim up and that he was going to kill him. And I'm going to fuck you up, white boy. He did pursue the victim after he was punched, as the victim has said, and that's evidence of his intent to commit a battery. And the victim did, in this case, did testify that initially he did not believe that the defendant was capable or had the ability to commit this unwanted battery. But when he saw the box cutter, we saw the knife, that's when he believed it. So that's when he feared for his life. The fear, the apprehension, that a reasonable person would have to fear a battery does not have to last the duration of the encounter. It can be formed in an instant when he sees that, and then it's there, it's present. So we believe that it meets the elements of this charge for the purpose of probable cause.
Okay, we heard her testimony from Mr. Prenny, and I won't go through the facts again. I think we've all heard them. The people have to show the probable cause standard, 4 things, and based off of Mr. Prenny's testimony, the people have met the burden of proof, and I'll get to the video in a second. 1, that the defendant did an act that would cause a reasonable person to fear or apprehend an immediate battery. In this case, based off of Mr. Prenny's testimony, that the defendant pulled out a box cutter and made threats. 2nd, that the defendant intended to either injure the complaining witness or to make the complaining witness, Mr. Prenny, reasonably fear an immediate battery. I do believe, based off of his testimony, that the defendant's words and actions of showing a box cutter or a dangerous weapon, which ended up being, according to Mr. Prenny, a box cutter, reasonably fear an immediate battery. 3rd, that based off of Mr. Prenny's testimony, appeared to have the ability to commit a battery. And 4th, that the defendant committed the assault with a dangerous weapon. In this case, what he thought to be a gun was an actual box cutter. There, of course, is argument from defense counsel and video that raises what will be, in my opinion, the question of fact for the trier fact, for the trier fact to resolve what appears to be a conflict between the complaining witness's testimony and video. His testimony was not completely incredible or implausible as a matter of law, and therefore not my role to dismiss. So he will be bound over at the probable cause standard for an arraignment on the information, Frank Murphy Hall of Justice, 3rd Circuit Court, for the date of May 4th at 9 a.m.
Oh, Your Honor, My client has appeared, at all proceedings. He has a GPS tether. There isn't any flight risk. He's not, trying to run for this case. I'd ask if the court would consider removing this GPS tether at this time.
Anything for the people?
We just ask that you continue on the same bond run.
I'm checking to make sure. Definitely is. I know you said that, I just want to make sure. Any take this.
No problem, Your Honor. I've been
Is he
on.
still on house arrest?
Yes. This is onerous, Your Honor, and this is gonna be to trial, and I could see if my client wasn't coming forward, I could see if he lived near there, he doesn't. He lives on the opposite side of town.
I'll lift the house arrest.
Thank
you. No contact with the complaining witness and no visiting that location on Gratiot. Where the incident happened. Understood, but I will lift the house arrest.
No problem. So, I just come on.
No, she's looking at her house arrest, but she's not.
Parties ready on Marquita Hardy. Calling case number 2260950, the people of the state of Michigan versus Marquita Hardy. Defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, false pretenses, $1,000 or more, but less than $20,000. This matter is scheduled for examination.
Good morning, Your Honor. Ed and Bookful appearing on behalf of the people, P 86266.
John Graziani, appearing on behalf of Marquita Hardy, P number 43387. Good morning.
Good morning. And Ms. Hardy, can you state your full name for the record?
Good morning, my name is Marquita Sade.
Thank you. Is everyone ready to proceed?
The people are not, Your Honor. Complaining witnesses failed to appear in this case.
Anything from defense?
I'm asking for dismissal, Judge.
Okay, as the people are not ready to proceed, I will dismiss without prejudice.
Thank you, Judge. Everyone have a good day and a good day.
I'm sorry. This way outside. Sorry.
Thank you, officer.
Or dismissal or?
I think we might have one next, with the.
We can call Mr. Simon's case next. That one's for sure.
But it's his client.
I have one I need to take care of over there, and then I'll come back.
I know. Right here.
Davenport?
Hi, Good morning. Me again.
Hey, I'm getting ready to go upstairs. Is this going to be?
A dismissal?
Okay, well, I'll do that before.
Well, we're gonna argue a little and then I'm sure you'll dismiss it.
Okay, so put on the record.
I'll just say the first word.
Thank you.
Ready for the weekend?
We don't know what's going on.
Oh, okay.
It's gonna be an argument. Yeah.
Oh. No, that's- No, I like-
Calling case number 2356253, the people of the state of Michigan versus Christopher Buchanan. Defendant is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, felony, firearm, count 3, weapons, ammunition, possession by a felon, count 4, weapons, felony, firearm, habitual offender for notice. This matter is scheduled for examination.
Good morning, Your Honor. Ed and Bookful appearing on behalf of the people, P 86266.
Good morning, Judge, to you and your staff. May I please with honorable court, Christina Shabbat Davenport, P number 82743, appearing on behalf of Mr. Christopher Buchanan, who's also present in the courtroom, and I'm standing in for the attorney of record, Curtis Davenport, with Mr. Buchanan's permission. Thank you. Please let me know.
Good morning, everybody.
Good morning, Judge.
Today's set up for an exam. Everybody ready to move forward?
The people are ready to proceed, but I understand Davenport did have a discovery order signed with the discovery issue.
Yes, Judge, I'll be very brief. There was a discovery order that was signed by Judge Giles on April 13th, and it was a very detailed discovery order. Actually, it was read to the record by the judge. I actually sent it by email. It was read to the record. The judge signed it and provided a copy of the signed discovery order to the prosecution on that date. I have been following up with the prosecution throughout the week, just indicating that I still do not have any discovery. I only have just one interrogation video. I spoke with the officer in charge as well as 2 officers in the hallway, and the discovery does exist. There are body worn cameras, and they have been, they failed to be uploaded. And so I am not ready to proceed because I cannot have a full cross-examination of any of the officers without that full discovery. So I'm asking for dismissal at this time, Judge.
Easy for the people.
Yes, Judge, everything Ms. Davenport said was absolutely correct. I was in constant contact with the officer in charge to have this uploaded. They really did try. From what I understand, the systems for body cams recently changed. This being so many body cams in such a large file, they really had trouble doing it. They completely understand why this case may be dismissed today, and they have indicated to me that they would reissue.
Reissue without the video again?
They would first successfully upload that body cam, and then they would reissue. That's what I've told them to do.
So it does exist?
It does exist, that is correct.
All right, with that, I will dismiss without prejudice, as my only concern is if it exists and it's not provided, then that's a problem. So I will dismiss without prejudice and charge it to, not the people, the prosecutor's office. I don't believe you withheld anything, but the DPD not providing it or being able to upload it to the fence on the day or prior to the day of the exam.
I appreciate that, Your Honor. Thank you.
Thank you, Judge.
I thought you said you could wait on your time.
Not that one.
Yeah,
I won't even
we
read
have
it.
a quick dismissal and a quick KPS. Yeah. Okay.
Sorry, I'm not sure, which one?
Yeah.
They don't tell me.
Right. So who's running the courtroom?
Right. They just trying to make it.
Yeah, I know. I know what y'all doing.
We just love to see you.
I'm ready to go.
I know you are, clearly. Appreciate you.
Yes, sir.
What's your name, sir? Good morning.
Ready?
Yes.
Ready. Calling case number 2356305. Okay, go ahead. The people of the state of Michigan versus Erwin Harris. Defendant is charged with count 1, motor vehicle, unlawful driving away, strike count 2, habitual offender for notice. This matter is scheduled for examination.
Good morning, Your Honor. Adam Booth, appearing on behalf of the people, P86266.
Good morning, Your Honor. Sophia Nelson, under Defender Service, on behalf of Mr. Harris, P77960. Mr. Harris is present here in court today. Mr. Harris, please state your name for the record.
Good morning to everyone. Are the people ready to proceed?
We're not, Your Honor. Miss Carolyn McCray was subpoenaed and is an essential witness in this case, and she failed to appear.
Your Honor, we will move to dismiss.
I will dismiss without prejudice, as the time is 11:23, and the exam was set today for, I believe, 10:45, and the people are now ready to move forward. Anything else?
Nothing complete. Thank you.
Tell it. You can wait all. This is a parent stuff that yesterday is.
Katie, what did you think?
But you could set that.
There's everything done. Well, Jefferson is cashier. It's just got
And determine where you're playing, it's booked to the jail.
I know, right?
I they're giving you $1,000 first.
Oh, you wouldn't, I don't think, yeah. Yeah. it's-
Sure they show up.
I know.
I haven't played in like 2-3 years. Not serious.
Yeah, right.
I played Saturday with my niece.
Oh, that's.
And
All right, and here's for here.
Playing what? Basketball.
We got the,
You play basketball? High school. It's in my past too. I'm 36 now, so it's kind of, yeah, it's different. My knees are, yeah.
You were early here.
Is this yours, Mr. Simon?
no.
Feels older than when I was 16.
36.
Sign what?
The house arrest.
Yeah, I did it. I don't think you were in the courtroom.
They told me I had to wait outside.
Yeah, she signed it, I got it. We ready on Dudley? Calling case number 2060457, the people of the state of Michigan versus Aaron Dudley. Defendant is charged with count 1, false report of a felony, count 2, insurance, fraudulent acts, habitual offender, 4, notice. This matter is scheduled for examination. Defendant has been to appear.
Good morning, Your Honor. Ed and Book appearing on behalf of the people, P 86266.
Good morning, Your Honor. Jonathan Simon, P 35596 on behalf of Mr. Dunn. Your Honor, PCC was conducted last week before Judge Giles. At that time, Mr. Dudley was made aware of today's date. I tried to call him 3 times this morning, but I'm not receiving any response. At the PCC, I had not yet received any discovery. Judge Giles made it clear that the discovery was not furnished by today, that he would be inclined to dismiss the matter. Your Honor, I don't know why Mr. Dudley's not here. The discovery's not here. The people probably may never be able to proceed with this case. So I would ask in the alternative, either that the court allow me to waive his presence for the purpose of a dismissal or to adjourn the matter.
Anything from people?
Everything Mr. Simon said was absolutely correct, Your Honor. I did everything I could to find discovery. I was unable to find any paper file, nothing digital. I emailed my officer in charge for a copy of the jacket and never received a response. So if Mr. Dudley was here, I wouldn't be able to proceed. The case would be dismissed anyway, but I'll leave it to the discretion of the court to allow the dismissal. That's totally fine.
You just needed your client here. Attorney Simon?
Judge, I don't know why he's not here. I called 3 times this morning.
This is not a motion to dismiss from the people, is it?
No, Your Honor.
Okay, well, I'm gonna issue a takers. He needs to show up. He doesn't get rewarded for not showing up.
Understood.
So
I'll
it'd
see
be
if I can
5,000
perhaps-
cash surety.
I'll see if I can arrange to walk with them before Judge Giles sometime in the near future.
Okay.
Thank you, Judge.
Thank you, Your Honor.
Yeah.
There was a couple of.
I just need one more. Can you just sign this next one? Thank you, Judge.
Judge Sabri's never coming back down here.
I know. They kept me hostage.
No, you have to.
Can I approach on an unrelated matter?
Yes, is that a search warrant?
It is a witness detainer
Oh,
for Judge
okay.
Giles.
Well, that's even
But-
better.
Okay.
What's going on?
It's an exam schedule. Tuesday, Judge Giles and a witness.
Yeah.
So,
I appreciate it.
Being initially notified.
Yeah.
They made multiple attempts at his house. If I access myself. Yes, it's armed robbery. There's ultimately two armed robberies, proceeding concealing. Four exams both on Tuesday, but this is just one witness or more.
And what is the, I'm gonna read this. What has done or she done to
He had spoken to the officer, but she doesn't respond. She won't pick up his phone, and the officer's gone to his house multiple occasions. And he said, "You need to speak to him."
I need to.
It was a hung jury.
That's what I heard. So you guys heard till like my body.
Well, 9:30. She was here at 10. So. Excuse me, I'm trying to track something down here.
Good morning.
Good morning. This is John Goldpaw. I don't have something up this morning, but I'm trying to get in touch with the prosecutor. And
We have a couple prosecutors in here.
we have an exam set for tomorrow, and I've made numerous attempts to obtain the paper discovery. I filed additional information. At the time the exam was set, the prosecutor indicated, and I believe it was Rima, that she would be forwarding it to me immediately. I have not received it. I've sent a second request both to Rima as well as to Mr. I believe his name is Putstaka. And I don't have the paper discovery. Pardon?
What's, first of all, Mr. Gopal, what case is it? Can you give me the, oh, is it Jalen, Charleston?
That's correct.
Okay.
Don't give away this link, man. I'm hard up.
And we.
Don't give away this link.
Oh, it was Remo was the prosecutor. It's a CCW. Except for tomorrow.
I still have. I'm sorry, pardon?
You know about the fix.
I don't know what's going on.
So what are you trying to do, Mr. Gopal?
I'm trying to get the discovery for tomorrow. I don't even know what the exact charges are against him.
Oh, saying you never got discovered.
Oh, well, if you don't have a Mr. Gopal, I probably don't have it either, so it'll just be a dismissal, but I'll double check and, I'll take a look. What's your client's name?
It's
Charleston? Do you have
Right.
Charleston? I'll take a look. Look, honestly, if you don't have it, it's probably because I don't have it. And then in which case it would be a dismissal, but I'll let you know, okay?
Okay, well, that's fine. If I don't hear from you, we are scheduled for in-person tomorrow, so we'll go from there. All right.
Okay. If
All
you don't
right,
hear from me, don't have.
And if we come up with it, then we'll have to reset the in-person exam. Fine, I'll notify my client and make sure. Thank you.
Okay, fine.
Okay,
All right,
and
so-
I'm sorry, your name's, sir, I'm sorry.
Eden Book Club. I'm gonna be the attorney in here.
Okay, can you spell that for me, please?
Sure, EDIN.
Okay.
My last name is Book Club, BUKVA.
Oh, okay, I saw your name. I apologize when I mispronounced, because I sent you a letter, I sent you an email, as well as one to Rima. Okay, thank you.
Okay. Perfect.
Thank you very much.
Another one?
I sent the.
You know what? I just seen it, but I thought it was the same.
No, it's okay. It's for an exam that may or may not go.
Does it say lab form? Okay.
I just need,
So I can't remember. Remember, was there an issue of Brianna Mitchell's court date on the 27th?
I don't remember. I can take a look. I'm pretty sure we set it for next week. Is everything too? Alex appeared on there. Yeah, he appeared on there.
Okay, I think it's okay. I think I just got confused with,
He's on his way, I just want to find out.
it was that other case that Daniel Williams was on.
That's the one that we adjourned to. the
Right,
16th.
to 16, okay, that's, all right.
Okay.
Oh, you want-
I don't want to get you. We got 3 more to do.
You want that too?
Have
Me?
you told him Mr. Cruz?
No, I haven't talked to
Oh,
him.
yeah, you thought. We got 3 more cases. Cause he has their prison.
Yeah, you told me it was that.
Yes, Mr. Martin. Land is here, waiting on his client, but still we don't have a judge. Have you talked to any judge?
And then another thing is, if Crips don't come, there ain't no officers check in on, get an attorney to stand.
That's what we see. Now you gotta let me know.
All right, excuse me for my bladder bust.
I ain't gonna let you.
But the thing is this.
Excuse me for my bladder bust. That's why I had to get up out of here.
This is like your bad. I am too. Cause he's not here, we gotta do last case.
We can mess around and triple over to lunch.
I just hope she could say, tell me if we got a judge. Man, it's not prison. Richard, we before like it's 11:30. You see what I'm saying? We got Richard. And they don't come up before we get a judge. See, that's the only reason I'm saying that we got something.
You saying this last name, it's just.
But
You saying that's what.
don't come up with no, Mitchell at 11:30.
Nah, see, so that's.
All right.
You saw Jessica's name.
No.
Someone name for what?
He get Boston.
We got that's what he did.
You wanna call again?
Oh.
Yeah, I'm gonna call right now. Where's my call, man? Yeah, I have business to take care of. My business.
Come before Ronald.
That's a lot of business.
Your business come before Ronald.
I ain't gonna tell what your business was, when they friend. Oh, that's very friend.
Y'all got some oatmeal in here, huh? That's why I donate money.
You like to cracker?
And you know what I don't eat? Oh. One of these.
So, were you able to get it in?
Huh?
Were you able to get the rest?
I went to the one out here.
Oh, 'cause I know.
I was on my way there. I said, no, it's always somebody in there.
'Cause I was getting ready to
I
tell
didn't
you.
have time.
Okay, so I'm gonna call this guy. Mark.
Another bag.